Good morning, everybody. Good morning, guys. It's your girl, Legal Bees. How y'all doing today? Happy Friday. And I'm still struggling to get my voice back. It always takes a long time for me to get my voice back after being ill. So, yesterday, as you guys heard, it just didn't go as planned. And again, as I said, I will go into a story time about what happened in court yesterday. Now, that aside, then I had federal court and I had other things, and we wound up going out to dinner last night, and I was just conked out. Yesterday just conked me out. I did finish the Crumbley trial of day one, but did not get to, post my remarks. So I'm going to start with the openings. I feel like, well, first off, again, for those who have never seen my videos or don't know me, my name is Attorney Kiana Franulic. I am an attorney in Michigan. I practice in the Tri-County area and abroad. And I practice in Oakland County, which is the same court where the James Crumbley case is currently pending and where his wife's case was pending. I am not... I haven't worked on this case. I haven't seen any discovery outside of trial. I am not affiliated in any way with this case, so I just want to get that out there so there's no question. I'm giving my opinions as a criminal defense attorney who's been doing this about 15 years and also a parent in some aspect. So when it comes to openings, I was kind of shocked with the direction that was taken with the openings by the prosecutor. The prosecutor kept reiterating in his opening that only one person could have stopped this, one person could have done this, and he kept using this phrase, one person, one person, one person. And I was really intrigued by the use of that language, because if only one person could have prevented or precluded this, then why are two people on trial? And I don't know if anyone else caught or paid attention to that little nuance of words, but to me, it just pops in my head, well, someone's already been convicted. So, all right, one person, we get that. Now, also take into consideration the fact that there was some little preliminary matters that took place prior to trial in regards to specific pieces of evidence and exhibits, particularly the text messages of Ethan Crumbley and Jennifer Crumbley. They were precluded by the court, which I think is huge and could have such a powerful impact in the outcome of this case, because those specific text messages are what led to specific knowledge on Jennifer Crumbley's behalf. And so basically the argument is, how do you place that personal knowledge of hers on him? And so they're precluded from being entered. So now, like I said, so going back into the opening of the prosecutor, I thought that focusing on, one person, etc., and mentioning what I think are unnecessary ancillaries about the fact that, we're not accusing him of murder. We're not saying that he murdered these people. He's charged with involuntary manslaughter, etc., etc. Well, we know that he's not charged with murder. We know he did not kill these people. I thought it was a waste of words, quite frankly. And even the repetitive nature of it was unnecessary, in my opinion. I think the focus really should have been on the neglect aspect of the case, particularly the neglectful aspect and the omissions that were made, which led to these young people losing their lives, their son having possession of this firearm, etc., etc. Which is why I previously indicated I'm surprised that a child abuse charge was not added for child neglect, because proving that neglect would have assisted in proving the involuntary manslaughter. in my opinion. And so what I think, because there are some key pieces of evidence that are not being admitted in this trial, that was admitted in Jennifer Crumbley's trial, I think he really needed to focus on the neglectful aspect of James Crumbley himself, and spelling that out a little bit more clearly in his opening. And that's just my opinion. Now, alternatively, when we get to the defense's opening, I will be honest, I am not wholly familiar with his defense attorney, but I am already a fan of how she did her opening. She knows that there are certain things that are just kind of stacked against her, and she could not play up. And I think she was very smart in keeping her opening quick and very short and succinct, pointing out little key things and cutting it down. I am also very pleased that she did not use a defense that made Mr. Crumbley seem like the most protective parent, the most I guess you could call, helicopter parent or anything like that. I'm glad she didn't use those types of things, because she would have, I think, kind of narrowed an eye point of his parenting style and type, instead of it's just a regular guy, it's just a regular parent. And I really like that. I think one of the things that kind of went wrong, in my opinion, with the Jennifer Crumbley case is the hypervigilance that kept being played up as the defense for Jennifer Crumbley. And everything that was entered and presented showed that she was everything but a hypervigilant parent. And so I'm glad that it's not the same tactic that was taken here. And I'm glad that there was not a lot of focus placed on Jennifer Crumbley as well, because I think that in the Jennifer Crumbley case, they attempted to use Mr. Crumbley as a scapegoat, as placing all the blame on him. And in the opening, in James Crumbley's case, his attorney did not really, place blame on either parent, but that the shooter is the one responsible for his acts. And so I'm really glad at how that played out. Now, on the flip side, the way the trial ended was completely taken off guard. The fact that, it seemed like trial to me ended kind of abruptly, but with, them approaching the bench regarding the testimony of the detective that was on the stand. And then, the jury leaves, and then it goes into, they're arguing to restrict the communications of James Crumbley, because apparently there are recorded jail calls of threats. Now, that was not said upon the initial argument. It was not said until they got more and more into the argument that there were threats allegedly made by James Crumbley. But we don't know to whom. We don't know who he allegedly made these threats to. We don't know what the context of those communications were, but it ended with him having his communications limited to essentially counsel and clergy. That is very fucking significant. Very. And I'm coming at my end, so I'm going to tell you guys why in part 2. All right, I'll see you in a moment.